Good day, I'm Rita du Plessis, an admitted attorney specializing in medical and commercial law. Medical negligence cases are becoming more and more prevalent, as is clear from various new cases being reported every day. RAF attorneys seem to be venturing into this area of law, often without any training then whatsoever, causing them to be ill-equipped when attempting this high-risk type of litigation. While quantification in medical law is largely similar to that in RAF matters, merits, including negligence and causation, are much more difficult to prove. Expert evidence is indispensable in these type of claims, and one may look at how the Supreme Court approaches it in the case of Mediclinic versus Vermeulen. Medical law is complicated by the interplay of various legal principles, including those related to delict, contract, labor, constitutional, and other areas of the law. These are found in various pieces of legislation, including the National Health Act, the Mental Health Act, and the Consumer Protection Act, to name but a few, as well as a myriad of complex case law. It can also be argued that the protections in the Consumer Protection Act would be applicable to the doctor-patient relationship, in that a medical service provider would qualify as a supplier and the patient as a consumer if one has a look at the definitions. The courts have, however, not yet considered this. Further complicating things are the intricacies involving the highly technical nature of medicine, the science behind it, practices, procedures, and protocols not commonly known to laypersons, and which lawyers may not previously have had exposure to. It is thus of the utmost importance to understand and educate oneself on these medical principles, as failure to do so would lead to not conducting such cases properly. These principles are further applicable to both public claims against the MECs for health in the various provinces and in the private sphere, unlike RAF, which is just a statutory organ. Claims against insurance companies of private medical practitioners and private hospitals, as well as those against the state, are known to be vigorously defended, and settlements are much more rare. The reason for describing medical law litigation as high risk is that ill-investigated, unfounded claims may have very high cost orders against your clients, who are very often indigent. Most of these matters are done on a contingency fee basis, and failure, when high costs of experts have been incurred on behalf of the client pending settlement, could financially ruin a firm. Professional negligence claims against the attorney, who is said to be the captain of the ship, is also a possibility. Costa bonus proprius have already been ordered by various courts around the country against attorneys and advocates for not conducting medical law matters properly. Even though we are not aware of a claim for defamation as yet, it's only a matter of time before a medical practitioner whose reputation and career has been ruined by false allegations of medical negligence takes on not only the plaintiff in such an action, but also their attorneys. This may be successful if one has regard to the court's attitude towards attorneys who are not properly prepared and bring baseless matters to court. These medical law cases thus require more time and effort than most. One cannot take on a large quantity of these matters, nor rely as much on support staff, as this is a highly specialized field. You must also know the facts of the matter backwards, as the smallest oversight might cost you your case. The relationship between the doctor, hospital, or other medical service provider and the patient is either based on contract or delict, or both. The most important duties include that the practitioner must treat the patient with reasonable care and skill and keep the patient properly informed, especially of the most prevalent and serious risks associated with the proposed treatment. These are both implied contractual terms and delictual duties upon the medical practitioner due to their calling. Consent, in order to act as a defense against assault in the medical sphere, must be informed consent, which is sui generis to medical law and is well documented by the court in the matter of Castel versus de Greve. Regarding limitation of liability or exclusionary clauses in hospital admission forms, it may be argued that Regulation 44 of the Consumer Protection Act may render such terms to be deemed automatically unfair. This has, however, not been tested by our courts yet. The test for negligence in medical malpractice is also not that of the reasonable person. The standard of care their actions should be measured against is that of the reasonable doctor, nurse, or specialist, or other medical practitioner in the same field under the same circumstances. Would such a practitioner foresee damage and take steps to prevent it from occurring? If so, and it is proven that the defendant failed to do so, their actions would be negligent. Various cases have solidified this test, and it has most recently been applied by the Supreme Court of Appeal in Kluwer versus de Goede in 2015. Notice to be taken that a mere error or a misdiagnosis will not necessarily be negligent, as it will always depend on the circumstances in that specific case, especially in light of the fact that medicine is not an exact science. When considering how to prove negligence, one must put before the court what the reasonable standard is, unlike in other defects where the court knows what the reasonable layperson would do, as well as prove the fact that the doctor did not comply with the standard. When it comes to the maxim of res ipsa loquitur in Goliath versus MEC for Health Gauteng, the Supreme Court recently held that there was no rebuttable presumption, but rather a duty on the defendant to supply evidence against a prima facie case of negligence, failing which a negative inference would be drawn. Many medical law cases are further won or lost on the aspect of causation. For factual causation, the but-for or sine qua non test is applied, but the results are often not clear due to many factors and technically complicated facts being involved. This was well documented in the Wright versus Mediclinic matter. When it comes to legal causation, in Smith versus Abrams, the Supreme Court held that the act had to be sufficiently closely linked to the damage to impute liability on the doer, if regard is had to public policy considerations. This is thus a pivotal point. A few practical examples to assist practitioners to obtain documents, which appears to be a big problem, is before litigation commences to bring mandamus or Anton Pillar applications or applications in terms of the Promotion of Access to Information Act. After litigation commences, the court rules may be used. If all else fails, however, and the documents cannot be obtained, rely on the Goliath matter and ask the court to draw negative inferences as a result of the documents not being available. To find experts willing and able to testify with practical experience and academic background is often very difficult. Read reported case law, judges name and give their impression regarding reliability and quality of these experts' opinions and their testimony in court. Universities and academic hospitals may also be approached for referrals. The South African Medico-Legal Society, whose membership include experienced experts, may be joined, and you could also ask your colleagues who they use. From this discussion, it's absolutely clear that it's of the utmost importance to inform yourself and educate yourself, not only in medical law, but also medicine. Investigate and prepare thoroughly before instituting action on any medical matter. Spend more time on these types of matters due to the complexity of the facts and the applicable law. It's recommended that you attend a course if you're going to delve into the medical law world if you have not had training previously. Thanks so much for watching.